Hello everyone! For today's video, I am here to discuss to you the Obligation and Contracts, Chapter 3, Form of Contracts. What to discuss? Article 1356, Article 1357, and Article 1358. So let's dive in right away to the first article that we could have to discuss when it comes to the form of contracts, and that is Article 1356. According to Article 1356, contracts shall be obligatory in whatever form they may have been entered into, provided all the essential requisites for the validity are present. This would be the general rule to whatever the forms that contract is entered into by contracting parties. So the general rule is that it would be valid or binding. However, when the law requires that the contract be in some form in order that it may be valid or enforceable, or that the contract be proved in a certain way, that requirement is absolute and indispensable. In such cases, the right of the parties stated in the following article cannot be exercised. So that would be the exception to the general rules. And now, let's talk about what is the form of contract. The form of contract refers to the manner in which a contract is executed or manifested. So this means that how to execute the contract. So the contract may be in oral or in written. So let us talk about the form of contract. The contract may be oral or in writing, or partly oral and partly in writing. If in writing, it may be in a public or private instrument. So it may be expressed when the parties expressly set forth their intentions, or implied when their intentions may be inferred from their actions or conduct. So when can we say that a contract considered in written form? It is generally recognized that to be in a written contract, all its terms must be in writing. So a contract partly in writing and partly oral is in legal effect. So now, what would be the classification of contracts according to form? So according to the form or method used in creating contracts, they are: first, informal or common or simple contract; second, formal or solemn contract. So first, informal or common or simple contract, or that which may be entered into whatever form provided all the essential requisite for validity are present. Article 1356, this refers only to consensual contract, such as the contract of sales. Always remember, consensual contracts are contracts that are perfected by mere consent, but not all contracts are consensual contracts, because there are also real contracts and solemn contracts. For example, in a contract of sale is a consensual contract. So an informal contract may be oral or in written. And now the second classification is a formal or solemn contract, or that which is required by the law for its efficacy to be in a certain specified form. And what would be the rule? So let us know what is the rules regarding form of contracts. So contracts are binding and therefore enforceable reciprocally by the contracting parties, whatever may be the form in which the contract has been entered into, provided all the three essential requisites. So consent, object, and cause for the validity are present. In general rule, so a contract may be oral or written. A written contract may consist of a letter, memorandum, note, or other instrument without following any particular form or language, it being sufficient that a parties clearly express their intentions. The main goal of the law is to respect the stipulation of the parties and in the manner that the contract are entered into the parties. In general, the contract are binding and enforceable to the parties. For example, Jane left a note in the store of Callie offering 2,000 pesos for a table Callie is selling. The following day, Callie called Jane by phone accepting the offer of Jane, who promised to pay the next day. So in that case, the same contract of sale is valid and binding. So, the note and the oral acceptance constitute a legally enforceable contract, and both Jane and Kali are fully bound. So, that's the general rule, and there are exceptions. First, when the law requires that the contract be in some form to be valid. Second, when the law requires that the contract be in some form to be enforceable or prove in a certain way. Third, when the law requires that the contract be in some form for the convenience of the parties or for the purpose of affecting third persons. So, the reform for validity of contract. There were cases when the law requires that the contract be in certain form for the validity of the contract. For example, donation of real property, so it must be in a public instrument. Second, donation of personal property, the value of which exceed 5,000 pesos. So of course, the donation and acceptance must be in writing. Next, the sale of land through an agent. So the authority of the agent must be in writing, otherwise the sale is void. Fourth, stipulation to pay interest. So of course it must be in writing, otherwise no interest is due. And lastly, contract of partnership. If immovables are contributed, it must be in public instrument, to which shall be attached a signed inventory of the immovable property contributed. So, if there are form for validity of contract, of course there are also form for enforceability of contract. So, in the cases of contracts covered by the statute of frauds, the law requires that they be in writing subscribed by the party charged or by his agent. So, if the contract is not in writing, the contract is valid. But it cannot be proved and therefore it cannot be enforced by either party if the other refused to perform the contract unless it is ratified by the letter. So we all know that an enforceable contract are contracts that are actually valid but they are enforceable unless ratified by the parties. So, under Article 1357, if the law requires a document or other special form, as in the acts and contracts enumerated in the following article, the contracting parties may be compile each other to observe that form. Once the contract has been perfected, this right may be exercised simultaneously with the actions upon the contract. So, a certain form, such as putting in a public instrument, is required for the convenience of the party in order that the contract may be registered in the proper registry to make effective as against third person the right acquired under such contract. So non-compliance with the required form would not adversely affect the validity nor the enforceability of the contract between the parties themselves. So, as between the parties, the form is not indispensable since they are allowed by law to compile the other to observe the proper form, and this right may be exercised simultaneously with the action to enforce the contract. It is essential, however, before a party may be compelled to execute the required form, the contract be both valid and enforceable. For example, Kali donated real property to Jane in a private instrument. The donation is valid because the donation of real property is required to be in a public instrument to be valid. We know that donation is void because under Article 749, donation of real property must be in a public instrument. So in the example that we're given, it was only in a private instrument. So we know that the donation is void, and since what was required in this case is a public instrument that they've only done is just a private instrument, then in that case Article 1357 would not apply because contracts is not valid to be begun with. Now for the last article for this discussion, under Article 1358, the following must appear in public document. So first, acts and contracts which have for their object the creation, transmission, modification, or extinguishment of real rights over immovable property. Sales of real property of an interest therein are governed by Article 1403 and Article 1405. Second, the cessation, repudiation, or renunciation of hereditary rights or of those of the conjugal partnership of gains. Third, the power to administer property or any other power which has for its object an act appearing for which should appear in a public document or should prejudice a third person. Fourth, the cession of action or right proceeding from an act appearing in a public document. So all other contracts where the amount involved exceeds 500 pesos must appear in writing, even a private one. But sales of goods, chattels, or things in action are governed by Article 1403 and Article 1405. So contract must appear in a public document. So contract covered by this article are valid and enforceable, though not contained in a public document or instrument or in writing. The public document is required only for the convenience and greater protection of the parties and to make the contract binding as against third person. In other words, the law does not require accomplishment of certain acts or contracts in a public instrument in order to be validate the act or contract, but only to ensure its efficacy, so that after the existence of the act or contract has been admitted, the party bound may be ordered by the court in which the actions or suits it failed to execute the document. For example, creation of real rights over immovable property. As security for his debt, Jane mortgages land to Kali. This mortgage must appear in a public document. So the extinguishment of the mortgage upon payment of the debt by Jane must likewise appear in a public document. Sales of real property or an interest therein are governed by the statutes of frauds. Second, cession or renunciation of hereditary rights or those of conjugal partnerships of gains. For example, X and Y are heirs of Z. Their decrees of father, X being financially stable, renounces his share in the inheritance. So this renunciation must appear in a public document. Third, power to administer property. For example, P is leaving for the United States to study for 2 years. He appoints A agent to manage his property. So in this case, the authority of A to administer the property of P must appear in a public document. Fourth, cession of action or rights. For example, Jane mortgages land to Kali to secure the payment of a debt. This mortgage appears in a public document. So the decision by Kali of this right as a mortgagee to Paul must also be in a public document. Those are the 4 instances covered in the Article 1358. So that's all. I hope you've learned something about the form of contracts. Once again, good day and mabuhay.